Hi, my name is Nadav Ravid. I am the managing partner of Ravid Law Group. Our firm represents landlords and tenants throughout the country in connection with their commercial real estate leases. Each month, our firm publishes an article that covers various laws and cases that impact the commercial real estate lease business. And in the past several months, we've written about and talked about a few cases that have gone through the court system analyzing the issues that are triggered by the COVID-19 pandemic and basically trying to answer the question of whether or not rent is due despite in light of the pandemic. And early on, we covered a case which held that the tenant was largely excused from paying their rent as a result of the pandemic. And more recently, we covered a case that came out of New York where the judge ruled that effectively almost all of the rent was in fact due despite the pandemic and despite the shutdown. That was a case involving the Gap where their monthly rent was $3 million. And the judge there ruled on a preliminary basis that the Gap owed 90% of the rent that was due. This month, we're going to cover another New York case that involved a smaller party, a restaurant operating out of New York that decided that it had to shut down as a result of the pandemic. Basically, what happened was when Governor Cuomo issued the executive order that prohibited in-person dining at the restaurant, or at all restaurants, this restaurant shut down and they stopped paying their rent for April and May. And the tenant argued that the rent was excused due to the common law doctrines of frustration of purpose and impossibility. And the judge rejected those arguments and held that the tenant had to pay the rent in full. Now, the judge analyzed, I think what was key here are the particular facts of the case, and the judge analyzed the lease that the tenant signed, which was signed back in 2012 and was for about a 9-year term. And the issue in front of the judge was whether or not rent for 2 months, only the 2 months of April and May, should be excused in light of a 9-year lease term. And the judge ruled that when you sign such a long-term lease and you're talking about only 2 months, that's not enough to trigger the doctrine of frustration of purpose or impossibility. The judge distinguished that logic and reasoning with previous cases that held that frustration of purpose did apply, for example, where a tenant signed the lease and was not able to open and operate because there was a problem with the sewer system that required 3 years to correct after the tenant signed the lease. So in that case, that was deemed to be a significant enough amount of time where in that case, that judge ruled that there was a frustration of purpose. But here, again, analyzing 2 months out of a 9-year term lease, the judge did not think that that should excuse the tenant's rent. Now, interestingly, this case really only analyzed 2 months out of the 9-year term lease. But the reality is now we're going on 7 months of a closure. And so it would be interesting to see if the judge would have ruled differently had the judge been presented with the facts that are here today, where it looks like we have 7 months of closure with potentially an extended period of time of maybe up to 12 months, if not longer. Now, the executive orders throughout the country are starting to allow for some in-person dining, whether it's on the patios or elsewhere, but there still is a significant impact to a lot of restaurants. Some restaurants are unable to operate with patios. There's talk that in the winter season, it's going to be very difficult for restaurants to provide for such dining. So I think there is still more to come on answering the question of whether or not the pandemic, as we know it today, should serve as an excuse, or at least a partial excuse, for some of the rent that is due. And I would not be surprised if courts do decide that there should be some partial abatement. That's pretty much it for this case. We'll continue to monitor the cases as they come in. There have been a few other cases also out of New York, which also ruled similarly that the landlord was entitled to full rent. So again, we'll keep watching these cases out of all the states and report back to you as they come in. Thank you.